Hello, my name is Carl Christian Johannesson. I'm a staff attorney at the Minnesota Association of Townships. Today, I'll be discussing towns and their liquor licenses and their licensing authority, the types of liquor licenses, things like that. Before we begin, I do want to say that you should have received a couple of different downloads. The first couple are a couple of resolutions that we'll be discussing later, as the topic that they are referring to will be discussed. The other thing you should have received was a outline that'll follow the order of these slides, have expanded notes, as well as an area to take extra notes as we continue to discuss. Today's presentation will go through four major topics. First, we'll discuss the town's licensing authority, or really lack thereof, but we'll get more into that real soon. We'll talk about the definitions that are important to licenses. That includes the type of liquors and the type of licenses allowed. Then we'll specifically discuss the type of licenses, maybe some of the fees involved, the process, length, those kinds of things. And then we'll discuss the other considerations when consenting to licenses and whether the town should adopt any of these policies, or just a glimpse at what the county's process looks like. Like I referenced to earlier, towns do not actually have a licensing authority regarding liquor licenses. They have other types of licensing authority, but we're not discussing that here. Towns, for liquor licenses, consent rather than issue the license. The county is the issuer of the license. A consent is a formal statement by the town that allows someone else to do something within the township. So this will include fewer requirements in actually issuing the license. Counties are required to have public hearings. They're required to investigate the issue, or the issuee, the licensee. They have to use specific language, and they have to update that license frequently, and these things aren't required by the town. When consenting to a license, the town can do some of their own investigation, but following these requirements that counties have to is not mandatory. Looking in your packet of downloads, one of the resolutions within that packet is actually a consent form. So the town has the ability to use that license, to use that resolution, modify it to fit their needs, and then consent to the license if they so wish to. Now that we've discussed town's actual licensing authority, or lack thereof, I do want to get into some of this information that a town should be privy to when consenting to a liquor license, so that they're aware of what they are consenting to. Liquor licenses are broken down into two broad categories: on-sale and off-sale licenses. On-sale means the alcohol is consumed on the premises in which the license was issued. So these include bars, restaurants, bowling alleys, and dance halls, as well as other recreational facilities. An off-sale license is obviously the opposite of that. It's for consumption off of the premises of where the license is issued. So this includes liquor stores, convenience stores, drugstores, grocers, and other retailers. Obviously, there are some places that do both. For instance, many breweries will allow you to take a growler home while also consuming some of their brews on the premises. And so there are combination off-sale and on-sale licenses, as well as brewery licenses, and different ins and outs from there. But these are the two large categories that we should be aware of. Just as there are the broader categories under liquor licenses of off-sale and on-sale, on-sale and off-sale are both broken up into smaller categories and smaller types of licenses regarding intoxicating liquor, malt liquor, 3.2% malt liquor, and wine. So first I want to discuss malt liquor in general. Malt liquor is a ethyl alcohol that is distilled, fermented, is spirituous, vinous, or a malt beverage that contains more than 3.2% alcohol by weight. This really includes anything you would consider a liquor or an alcoholic beverage. So spirits, wines, beers, ciders. If we look over, we can see vermouth, sake, and perry also referenced, as well as ale and lager. So intoxicating liquor license is, for the most part, the broadest type of license you're going to find. Now, your intoxicating liquor is broken down into smaller categories. So you have wines and malt liquors. So first of all, malt liquor is really any beer or ale or other type of beverage that's made from malt liquor made by malt grain fermentation. So again, beers, ales, lagers, anything else you would consider in that beer category, IPAs for instance, are found to be malt liquors. Wines are any other type of a liquor that is made from fermenting grapes or other agricultural products, including grains that aren't malt. And these have to contain 0.5% alcohol and less than 24% alcohol. So your really strong spirits aren't going to be under the category of wine, but anything under 24% will. And so again, these includes wines, ciders, vermouth, sake, which is rice wine, or perry, which is pear wine. Cider is essentially apple wine. It's fermented apples. So these would fall under that category. Under the malt liquor umbrella, you have a narrow category of 3.2% malt liquor, which is a malt liquor containing over 0.5% of alcohol by weight and less than 3.5% alcohol by weight. This is really only sold at convenience stores and grocers. It's a oddity and somewhat of a specialty of Minnesota law. Minnesota is the only state that has really 3.2% licenses any longer. So if you see these, definitely take note of it, as Minnesota is one of the few states that has this. And this really is a remnant of when Minnesota didn't have Sunday liquor sales. And so these types of liquors could be sold on Sunday because you could buy them at grocery stores or convenience stores. And so now they're starting to die off a little bit and sales have been impacted. And Minnesota is looking for ways to allow convenience stores and grocery stores to sell over 3.2% malt liquor. But as of now, there's still 3.2% malt liquor being sold in Minnesota. And so if you care to use it, or take note of it while it lasts. As for municipal liquor stores, towns can't adopt municipal liquor stores. They're only able to be adopted in select cities. And these are liquor stores owned by the city that is revenue for the city, that the city can gain revenue through the sale of the liquor in those stores. We'll now look at individual types of licenses. First, we'll look at on-sale licenses, and then we'll look at off-sale licenses, and then we'll look at the more unique types of licenses that may encompass both that really don't fit well within either category. So the first thing I want to touch on are these 3.2% malt liquor licenses. Again, these are on-sale licenses, meaning they are to be consumed on the premises. But these are usually temporary licenses, and it's probably not going to be an issue, but they may be set, again, temporarily for a term set by the issuer, so the county, for 4 main types of events. So for charitable events, religious events, and 2 nonprofit organizations for, again, some sort of event that they're putting on for the purpose of the charity. Also, the county can issue it to a school or school buildings for an event put on by the school for fundraising purposes. The next type of license I want to talk about are intoxicating liquor licenses. So remember, this encompasses pretty much all type of liquor. This also includes 3.2% malt liquor. So an intoxicating liquor license is a broad sweeping type of license. These may be issued to bowling centers, restaurants, clubs, or hotels. And so really to any place where you would generally consume alcohol on site, that's where these intoxicating liquor licenses would be issued to. There are also some more interesting cases of on-sale licenses. So first I want to look at are these culinary classes. So these culinary classes are issued to locations that are not otherwise eligible for an on-sale liquor license, and that part of its business is to conduct cooking or culinary classes. And so these types of licenses are very limited. You can only allow 6 ounces of wine or 12 ounces of intoxicating malt liquor. So again, these are your beers, your ales, your lagers during the class. And again, these are during the class to each participant. So if they come back for a second class right after, they can have another 6 ounces of wine. There are also other types of temporary licenses that the county may issue pending town approval. So these are to clubs or charitable, religious, or other nonprofit organizations that have been in existence for at least 3 years, to political committees, or to a state university. And these licenses are limited to only being issued for 4 consecutive days, not any longer, but they may be issued for less time. One other type of license I want to discuss are wine or malt liquor educator licenses. These are both under the same branch of educator licenses, and they're mostly utilized for either wineries or breweries or distributors that are trying to teach people how to taste, describe that taste, and really tell the difference between these types of liquors. Of course, wines mean any fermented fruit or rice or other type of grain that isn't malt, and then malt is referring to specific types of liquors such as beers or ales or lagers that are created with the fermentation of malt. Again, both of these licenses are very similar. They are seeking to educate people, and from that are very restrictive in how these licenses may be used. Both of the structures of how to use the licenses are very similar, so we'll only go through it once. So first of all, the license may be used to purchase wine or malt liquor at retail and then serve for educational purposes. So they may purchase the wine at the educator place or the malt liquor at the educator's place, and then there it may be used for educational purposes. So it's not a restaurant or a bar where you sit down and you drink as you please. It's really utilized for specific educational purposes. Second, all the events conducted with this license must be conducted through advanced registration. So you can't show up at the place and not having previously registered enter in. You would have to register either by phone or over the internet or by mail, however the business is conducting advanced registration, to be able to register. The licensees, so the business, must possess certification that is satisfactory to the commissioner. So that's alcohol and gambling here in Minnesota, or at a federal level, alcohol, tobacco, and firearm. And so these are just going to be rules set in place. The county probably utilizes a more strict set of guidelines than the commissioner, but in general, the commissioner's rules are fairly simple to follow because everyone is at least going to adopt that at a base level. Otherwise, no licenses would be able to be issued for an educator license. 4, a license holder shall not sell alcohol for off-premises consumption. So even though you're at a brewery and oftentimes you can purchase or a winery, and you can purchase some alcohol to go. For the educator license, that is not possible. And at the same time, you can't order for future sales while at the place for the purpose of education. So you may be able to come at a different point and purchase for off-sale consumption, but not at the time of education. 5, classes shall not be conducted at retail businesses that do not have liquor licenses during business hours. So if the business is either one at a location where they don't already have business or liquor licenses, or at a remote business that doesn't have a liquor license, the class cannot be done. It would actually have to have both a liquor license and then an on-sale liquor educator license afterwards. And then 6, if the class will take place outside of the corporate limits of any city, so this applies to all townships, the licensee, so the business performing the education, shall notify the sheriff of the county where the class will take place. And this is just going back to the fact that towns are consenters, they're not the issuers, and so towns aren't really involved other than consenting to the actual license. Towns aren't really involved in regulating that license. Now we're moving on from on-sale licenses to off-sale licenses, or licenses where you can consume the alcohol on the premises where you purchased it versus sales off the premises where you purchased it. There really isn't much of a difference between the two. However, there are still some notes I want to make of some slight differences. 3.2% malt liquor licenses, again, are issued by the county, consented to by the town board. You have the resolution showing how you may consent. These can also be temporary. Much like the on-sale licenses, these can be temporary for certain types of, whether it be charitable, religious, or educational events. The town also has the authority to sell intoxicating liquor licenses. Again, town consents. County has the authority to issue, but needs consent from the township before being able to fully issue the license. This can also be temporary for charitable organizations and religious organizations and educational organizations. The county board, when issuing these licenses, must have a public hearing. This public hearing must be within 3 miles of the proposed location of the store. So this can encompass 2 townships, it can just encompass 1 township, but the county will have a public hearing. The county also runs into its relationship with cities and the city's authority to issue licenses. If the county board has to issue a new license to a person for an establishment located less than 3 miles from the most direct route of the city, well, it simply can't. And again, this is where the city has local authority over the county. The last thing I want to discuss that broadly fits under the license or permit category are, well, permits. These are not licenses, so there isn't town need to consent to these, but there are even more strict guidelines when adhering to these. These don't license a business to do more than a license would. First thing I want to discuss, and really kind of gives the broader idea of how these are limited and are only small permits rather than licenses to sell and allow people to consume alcohol either on premise or off premise, is this consumption and display permit. If a business does not have a sale license, they can allow consumption on the premise if it has a consumption and display permit. Businesses that may have these consumption display permits are restaurants, hotels, establishments licensed to only sell 3.2% malt liquor, resorts, clubs, and bed and breakfasts. Again, this is from people bringing their own alcohol onto the property and not from the actual business selling the liquor. The other thing I want to touch on are festivals and tastings. So you can have a wine festival, and these are issued to an association of owners of wineries. So I'm not sure if we're going to find much of these in Minnesota, but these annual festivals are for the showcasing of wine to the members of the association. At these festivals, only 2 glasses of wine may be given to a customer and an off-sale bottle. So 2 glasses of wine for on-sale consumption, a bottle for off-sale consumption. Purchasing the liquor isn't necessary. Free samples of the liquor are allowed, but again, only 2 glasses of wine for on-premises consumption. There's also other alcoholic beverage tastings. These have to be put on by a non-profit organization for up to a 4-hour session, but not anymore. You can only use the proceeds for the organization's nonprofit purposes or to donate to another nonprofit. There's also no off sale. So these are really like temporary permits you can utilize, or temporary licenses. You can utilize this session to try to build up funds for the nonprofit and pay back some of the costs from the tasting, but these are for the sole purpose of the nonprofit or another nonprofit and not for, well, really a profit. The final thing here is a tasting conducted by an exclusive liquor store. Very similar to the alcoholic beverage tastings, these are up to a 4-hour session. There's a fee to participate. You can't have any off-sale transactions during this time. And that the fees from the tasting can only be used to pay for the tasting. So if a store is trying to promote itself, or the store is trying to educate customers, then this type of tasting could be conducted, but it can only be utilized, again, not for a profit, but to show people and to educate people, much like the educational licenses that we discussed earlier. The last thing I want to discuss are just general licensing considerations, such as fees, what may and may not be a disqualifier, as well as the duration of license and any other issues that may pop up. Counties may issue fees for licensing. Towns can also charge an additional fee that is up to 20% of the county licensing fee. So for on-sale licenses, the township maximum is $160 because the county maximum is $800. And so $160 of a fee depends completely on the county fee. So the county may charge less, and then the township would also have to charge less. As for on-sale licenses, the county sets the fee for the most part. There are other types of licenses in which the county is restricted by state law, but generally speaking, the county can set a fee, and the town can charge up to 20% of that as an additional fee. For wine licenses, the county can only charge up to $2,000, and so the town can charge up to $400. If issued for a club, which is defined as an incorporated organization organized under the laws of the state for civic, federal, fraternal, social, or business purposes, for intellectual improvement, for the promotion of sports, or a congregationally chartered veterans organization which has more than 30 members. 2, has owned or rented a building or space in a building for more than 1 year that is suitable and adequate for the accommodation of its members. And 3, is directed by a board of directors, executive committee, or other similar body chosen by the members at a meeting held for that purpose. No member, officer, agent, or employee shall receive any profit from the distribution or sale of beverages to members of the club or their guests beyond a reasonable salary or wages fixed and voted each year by the governing body. Depending on the amount of members, towns can charge a small fee, just as counties have the ability to charge. So for instance, over 6,000 members, that means, over 6,000 members, the county can charge an annual fee of $12,000. And if we do the math, we go all the way back down, but that for townships explicitly at $60, $75, $82.50, $120, $200, $400, and $600, based upon the size of the club. When a county is looking to issue a liquor license, they will look to make sure that there aren't any disqualifiers. Minnesota Statutes 340A.402 lists four main disqualifiers. First is you have to at least be 21 years old to hold a liquor license. You cannot have had your license revoked within the last 5 years. Can't have any direct or indirect interest in a manufacturer. So this means if you own shares in a manufacturer, you're a part owner of a manufacturer, or someone who is closely related to you is. And then the last one, of good moral character or repute. And this one is more so of this is more subjective of a test. This is one that the county board has to work out among themselves. And here I have two examples of cases of good moral character and repute. One where the licensee was wrongly denied, and that's WIDA versus City of Minneapolis. And the one where one was rightfully denied, and that's Godfather Inc. versus City of Bloomington. And I want to go through each of those cases real quick, just to kind of give you an example of how the county is looking at these issues. So first I want to look at WIDA v. City of Minneapolis. Antoinette WIDA was the owner of a building that she purchased with her husband in 1954. This case is from 1974, so it kind of gives you the time frame. So she owned that for a number and operated that business for a number of years. It was a tavern that sold that had a 3.2% malt liquor license. Eventually, Miss WIDA's husband passed away in 1961, and then she gave operation to her son, Anthony WIDA. Anthony WIDA had some issues with the business. He was charged with violating ordinances and selling intoxicating liquor to minors. And eventually, Anthony WIDA, Antoinette's son, was told that if he found guilty, his upcoming renewal for a liquor license would be denied. So Anthony WIDA transferred his license over to a man named John D. Patterson, and he had no association with Mrs. WIDA or Anthony, and he also held a good record. However, during the time of Mr. Patterson's operation of the premises, there were a number of violations, and residents got involved sending petitions, arguing about nuisances and other such issues. Eventually, the license inspector told Anthony WIDA that he needed to show cause why his license should not be revoked, and instead Mr. Patterson told the license inspector that he was closing the bar and going out of business. Miss Whita was stating that she was losing money on the bar by just sitting there, and applied for an on-sale liquor license to be able to continue operation of the bar. She said that neither of her sons would have any connection with either ownership or operation of the bar. So going back to Anthony Whita, his issues would not be part of the bar. However, the committee that approved and disapproved licenses decided that Miss Whita did not qualify for a license. She was not of good moral character or repute because of past actions done by Anthony Whita's operation and Mr. Patterson's operation of the premises, and that Miss Whita's sons might be called upon to help Miss Whita if she granted the license. And I know this seems like a contradiction between operation and coming to help. It's not, because Miss Whita, of course, is just asking for help in certain instances. It's not going to be a common occurrence. Eventually, after a number of appeals, this got to the appellate court, where it looked at different issues and seeing whether that this was an arbitrary and capricious decision. So the court states, after a careful review of the facts and circumstances of this particular case, has convinced us that the City Council's action in denying Miss Whita's application was so arbitrary and capricious as to necessitate our reversal. The court continues to go on to state that the misconduct of other licensees, the city's record fails to show that there was any permissible basis for drawing adverse inference to Mrs. Whita's ability to properly operate the tavern from the fact that others operated it didn't do so responsibly. Instead, Miss Whita, when she ran the business prior to her husband passing away, competently ran the business, both herself and together with her husband, for a total of 11 years, during which period there were no significant violations or complaints from neighbors. And this instead is extremely persuasive evidence of her fitness to properly operate the premises in the future. Even the counsel for the city, the lawyer for the city, acknowledged that Miss Whita's record as a former licensee and her character were both impeccable. The city was also concerned that the tavern acquired a bad reputation and became a favorite, quote, hangout, unquote, of undesirable criminal elements from other parts of the city. Counsel for the city asserted that it would take a very strong person to overcome this reputation and return to the tavern to its previous mode of operation without legal violations or the neighborhood disturbances. Counsel for the city didn't state why he doesn't believe Mrs. Whita was a strong person, other than the fact that she was, at the time, a 58-year-old woman. The court found that a 58-year-old woman is not presumptively incapable of competently and forcefully managing a tavern in such a way as to prevent infractions and nuisances like those experienced from occurring again. The last point that I want to touch on is that the city's argument of the misconduct of former licensees should not have been considered a negative factor in Miss Whita's application, because she was just the landlady in this case. She wasn't involved at all in the business. In fact, she was very non-caring about the goings-on of the business, just that she was receiving her rent on time. The court states is patently evident, contrary to the evidence, which does not disclose that Mrs. Whita possessed any interest in business operations of either of these two preceding licensees or any power of control over their actions. Miss Whita did not had there's nothing in the record that indicates Miss Whita had any contact or relationship with Mr. Patterson other than as his landlady, and the record also does not demonstrate that Miss White had any knowledge of the tenant's misconduct. So here we can see clearly that Antoinette Wida maintained her actions quite well. She didn't. She showed good moral character and repute when she managed the business, whereas her tenants did not. And the city tried to deny her based upon the tenants, but Miss Wida obviously was not the tenant in this case and didn't have any involvement with the tenants. And so the city improperly denied her, even though Miss Wida showed that she had the ability to properly run the liquor store. Now the other one I want to touch on is Godfather Inc. versus City of Bloomington. So Godfather Inc. is owned by John Asanvino Jr. He's the sole shareholder of the corporation, and he was the facilities manager. The city of Bloomington conducted a lengthy investigation that culminated in a report filed by the chief of police recommending denial of a liquor license. There is also an administrative law judge involved that issued findings of fact and conclusions of law because of submission for a limited purpose of the finding of fact did not weigh the importance that the city might assign one fact or another, and issued no recommendation whether the license should be granted. So the administrative law judge just issued some findings of fact, and then it was up to the city to then decide how to treat those facts. So Asanvino was 47 years old at the time of this case. In 1977, he became the owner. Again, the time frame of this case is 1985. So in 1977, he became the owner and manager of Godfather Restaurant in Richfield, which closed in December 31st, 1984 because of condemnation proceedings. Also connected to Godfather Bar was Speakeasy Bar, which had a separate entrance from the Godfather Restaurant. In 1980, a fight erupted between two motorcycle gangs, resulting in a shooting. The use of drugs, particularly marijuana, occurred at times with the knowledge of bartenders, waitresses, and hostesses. And this all happened at Speakeasy Bar rather than Godfather. By 1984, most of the problems associated with the Speakeasy Bar had noticeably diminished. So at the time of this case, there aren't similar issues, but there were certainly issues in the past. In November 1981, a corporation controlled by Asanvino was granted a liquor license in the city of Medicine Lake to operate Vino's Godfather II, or just Godfather II. However, that closed down, and in 1982, the restaurant reopened as 3Gs, Games, Girls, Guys, Fun, and Food. And this featured both topless female and male dancers. However, the city of Medicine Lake passed a public nudity ordinance, and Mr. Asanvino said that he would not reopen the bar unless the city underwrote his losses. And then the city later agreed to not enforce a citation until it passed a constitutional ordinance, which it did on 1982, and soon thereafter, Asanvino closed 3Gs. At the administrative law hearing, it disclosed that many of the people working at Asanvino's restaurants did not have federal, state, and social security taxes withheld, which again is an issue. And then he was also asked if he had any legal claims, which Asanvino replied no or none. However, he was in the process of many legal claims on behalf of a corporation known as Arrive Alive, as well as other dram shop suits against Godfather Inc. Ansovino nor any of his establishments were ever convicted of violating any liquor ordinance or statute. However, he was still denied a license based upon his good moral character. The courts look at these factors. One, that the applicant failed to withhold state and federal income tax. The applicant failed to prevent others from using drugs at Speakeasy Bar. The applicant failed to disclose on his liquor application that he was a defendant in a number of lawsuits, and the applicant refused to show that he would cooperate with the City of Medicine Lake by operating a topless dancing show in his establishment. The court looked at all these factors and denied Ansovino because of this. And it's fairly clear here that Ansovino did not have good moral character, where Mrs. Wida did. There are still a few other issues I want to discuss that didn't fit well with any of the other categories that we were going through. The first is that although we've been discussing towns' ability to consent and towns don't have the licensing authority, there are certain towns, urban towns, in Ramsey County that do have the authority to issue liquor licenses. So here those towns have taken that authority and the county is not involved. Next, towns don't have the authority to consent in some cases, so this is the opposite of some towns actually having licensing authority. Now we're discussing places where towns don't have any authority, they can't even consent. The first is for bed and breakfasts. Towns, of course, don't have the authority to consent here, same with catering. Common carriers is a little bit different. These are vehicles usually that are transporting liquor through the town. And so here towns also don't have the authority to consent to that or create any sort of extra restrictions that the county does not already have. As for Sunday liquor sales, if a county is going to issue a license that includes Sunday liquor sales, the town must first allow the town board to consent to that through an election, through a referendum. So either at the annual election or through a special election, the town board can present the question to the voters. Voters can vote yea or nay, and if a majority vote yes, then the town board can issue a liquor license for Sunday sales. And this is that last resolution within that packet of downloads that you should have received. As for alcohol in elections, just in general, they don't mix. So if your election place is connected to a bar of sorts or a place that serves alcohol, you have to be very careful. You can't have direct access from the polling place to the place that serves alcohol. Back in the day, there was a time where a polling place was attached to the same building as an American Legion. But there was no direct access from the polling place inside the polling place into the American Legion. Instead, you would have had to walk outside and enter the American Legion that way. So here the town board was okay in having their polling place there, as it was just like if you had a bar across the street from the polling place. In conclusion, I just want to say that thank you for listening. If you have any questions, please don't be afraid to call Matt at 1-800-228-0296, or if you want to ask me any further questions on town's licensing authority or liquor licensing authority, please email me at kcjohannessen@mntownships.org. Again, that email is kcjohannessen@mntownships.org. Thank you.